This is your version.
Yes, sir.
But when you looked at me in the eye and pleaded guilty, we went over all of this. You looked at me and said, I'm guilty of this.
This case opens like a slow-motion car crash. A Christmas party gone completely off the rails. We've got Daryl, a father, a full-time worker, a man who claims to have simply made a stupid mistake. But that mistake involves underage drinking, blackout drinking, and something the court calls a sexual assault. His defense? That he's remorseful. His plea? That he's a good man who lost control. But here's the catch. The judge isn't buying any sugar-coated confession. And as this hearing unfolds, you'll see how one man's attempt to downplay his crime crumbles under the weight of his own contradictions. Let's dive in, but be warned, this one gets dark fast.
We are actually asking for deferred adjudication probation. I have spent quite a bit of time with Daryl concerning this, and he strikes me as a very sincere man who made a very, very stupid decision right before Christmas of last year. As the report indicates, they were having a Christmas party at his apartment with his daughter, a couple of other friends, and the first thing he did that was really, really stupid was providing alcohol for them. They were close to being of legal age, but not of legal age, and never should have done it. And that's the one beginning really stupid thing that happened. And after that, he acknowledges that everybody drank way too much, including himself, that there's differences of opinions to exactly what happened. But frankly, he was pretty blacked out himself and doesn't even really recall the exact sequence of events. But he knows that something happened and something happened that should never have happened. He has told me that he totally accepts responsibility for this. He realizes that that was about as stupid a thing as you could do. He's written a letter to the court acknowledging that responsibility.
Right here, the defense paints Daryl as a sincere man who made a poor decision. Classic mitigation move: show remorse, humanize the client, downplay intent. But legal reality check: remorse only matters when it's consistent. The court isn't moved by vague apologies or letters that read like PR statements. Judges look for ownership, not excuses. And if your client writes a sorry letter that centers himself more than the victim, it's not repentance, it's reputation management. Viewers, what do you think? Should genuine remorse ever outweigh the damage done in cases like this?
Looking at his history, he's never had any felony of any sort, even accusations of felony. He was on one misdemeanor probation, but that was an evading arrest. It really had nothing similar to this type of offense. He's a hardworking young man. He works a full-time job as an operator at the plant. He's got a bunch of children that he supports and pays child support on. Basically, what he's saying is this was just about as foolish a thing as anybody could do. He deeply regrets what happened. In the recommendations, he does say, that I'm truly sorry for my actions. I never should put anybody in that situation. Learn my lesson. That should never happen anything like this again. Hardworking citizen who made a very poor decision. And I think that pretty well sums it up. Again, he's written a letter to the court that I've shown Mr. Laird as well. And if the court wants to address him or ask him anything else concerning it, I think I've kind of spoken to the heart of what you told me. He appears to me to be a very sincere man who is just accepting responsibility for something that was horrible. And thank you, court. He's asking the court to give him an opportunity to prove that nothing like this happened. Have I pretty much covered that, Darren? Do you want to elaborate or just wait and answer any questions that Judge has for you?
Let me just ask something here, Mr. Argon. Did you want to say anything before the state? No. Okay.
One of the things that helps us judges take care of our business is we get the pre-sentence report prepared by the probation office, and they do an outstanding job. I'm very proud to work with them. They help us greatly because there's a lot we don't know. Judges, the lady next door who handled these felony cases, there's a lot we don't know about. We weren't present. So we've got to make an important decision based upon the information given to us in spite of the fact we weren't present. And we have to rely on certain methods. And we rely on getting your opportunity to be heard and listening to you. And then the probation office seeks information from law enforcement who do the investigation. And then most importantly, the complainant, the victim in the case. And then they prepare a pre-sentence report. And this one is, read 4 pages, and it also has a supervision plan for the court to deal with. We have the indictment, probable cause affidavit, all these things.
Now, the real gravity hits. The charge isn't just bad judgment, it's sexual assault of a 17-year-old girl. In Texas, that's a second-degree felony, up to 20 years. What's chilling here is the defense's earlier tone, like this was a minor lapse at a Christmas party. But the judge cuts through that illusion. This was a predatory act masked by alcohol. And remember, intoxication doesn't erase consent laws. When the victim's 17 and the adult's in control, the law doesn't hesitate. This is the turning point, where sympathy starts evaporating and accountability takes center stage.
That we look at, so that's really some of the first impressions that the judges get, is preparing for this sentencing. Each party involved has a chance to speak. You, at your plea hearing, pleaded guilty to this offense that was indicted, second-degree felony of sexual assault, which alleges that on or about December 22nd, 2024, in Jefferson County, Texas, you intentionally or knowingly caused the sexual organ of a 17-year-old young lady, to contact or penetrate your mouth without the consent of that young girl, 17. And that's what you swore to and pleaded guilty to. You understand? You were sworn to and you pleaded guilty. So when you go to the pre-sentence investigation, this is what you say. Even though under oath you had pleaded guilty to what the indictment elements were. You say, my daughter and her friends always come to the house. Everyone was drinking.
Here's where it gets stomach-turning. Daryl claims the victim touched him first, flipping the script in a classic blame-the-victim defense. But legally, that argument collapses instantly. She's a minor. She cannot consent, period. And trying to paint her as the initiator only deepens the damage to his credibility. The judge's tone shifts here. You can feel the patience thinning. For viewers, this is where cases like this become moral crossroads. Do we believe the blackout story? Or is it a convenient fog to avoid guilt? Drop your thoughts below, because this defense move rarely ends well.
The little accuser you refer to as the victim in this case, my daughters went to get something to eat and she left her behind. We were intoxicated. Everyone was on the couch. She came, this is the victim, sat on the couch with me. We started fooling around with each other and I said, no, I'm not going to do that. She, the accuser, the victim, touched me. The defendant, you admitted to being under the influence of alcohol at the time of the offense and explained that you blacked out and don't remember what you did. That's your version, which was, it's her fault. That was what she did to me. But yet, under oath, in front of me, you had the audacity to plead guilty to intentionally or knowingly causing her sexual organ to contact and penetrate your mouth. Oral sex is what you did. That's what you pleaded guilty to. I don't see any of that admission in here. So are you lying to the probation office or lying to me? Would be pleaded guilty.
No, sir. No. That's exactly what happened. Like I said,
Now you have two different versions. Which one, if they can't both be right? Listen,
This line from the judge, "You can't have it both ways," cuts to the bone. And it's true, you can't plead guilty under oath, then turn around and minimize the crime in your pre-sentence report. That contradiction destroys credibility. Prosecutors hate it, judges despise it, and it shows the defendant still doesn't fully grasp the seriousness of what he's done. In legal terms, it undermines acceptance of responsibility, which often determines whether you get probation or prison time. Viewers, imagine being that judge. What would you think hearing two completely different versions of the same crime?
But when she says that because you were blacked out, you can't dispute that's actually.
I can't. Yeah,
That's what she said happened. It had to have happened.
It's been exactly.
this is your version.
It's a.
But when you looked at me in the eye and pleaded guilty, we went over all of this. You looked at me and said, "I'm guilty of this," and you were under oath. You're under oath. Well, it's an ancient document that's swearing. You took the oath. You can't have it both ways, sir.
Judge, if I might, state of Texas is not satisfied that he's accepting responsibility for what he's done, and that offer was made upon him accepting responsibility. So we would, at this time, withdraw the offer and ask this be reset for trial.
Judge, I don't think that the state's offer was contingent upon anything, but I do say that he is accepting responsibility for this. He's saying that he was unconscious. He doesn't know exactly what happened, but he cannot dispute that that's what she says. He said, if that's what she says happened, that's what happened. I may not remember it because I was blacked out, but if that's what she says happened, then that's what happened. And that's the way he's related to me. I think that's
What do you?
that's where we are, and I think the state should be bound by their offer.
I think they got fair. I think they have a fair issue that's brought up. You can't have it both ways.
He's accepting responsibility.
I'm accepting the responsibility, and I guess what I told the.
You're accepting responsibility, but you have two different versions.
I say I was drunk that night. I was out of here.
Who caused that to happen?
I did.
You have. You know, voluntary intoxication is not a defense to any crime.
Yes, sir.
Here, the judge lands a crucial legal truth. Voluntary intoxication is not a defense to crime. It's one of the most common misconceptions defendants cling to. I was drunk, I didn't mean it. But in the eyes of the law, if you chose to drink, you chose the risk. And what's worse, Daryl was on probation at the time of this offense, meaning he knew better. That's double jeopardy on morality. This moment shifts the hearing from defense to damage control. The excuses are evaporating, and the consequences are closing in fast.
Okay, so that's your problem. You put yourself into it. But what we have here is a 17-year-old who was sexually assaulted. Let me ask you this. How do you give that back to her?
Okay.
Her innocence.
Okay.
No. And you're responsible for that, the adult. I don't even know what the price, you can't set a price on it. But one other thing, before this occurred, in 20%, in your pre-sentence report, you had an evading arrest or detention offense charged against you. It was a misdemeanor, and boom, you ended up being convicted on that crime. You were sentenced to 1 year in the jail. Then you were placed on probation for a year. That looks like it was extended for 18 months. And Is that right?
Sir.
Was it, when it said 1 year jail, 1 year disposition, 10/9/23, 1 year jail / 1 year adjudicated probation and $1,000 fine, 10/1/24. And then semicolon, 18 months extension. I really don't understand what that means.
Are you still on probation, misdemeanor? You're off of.
Yeah, I'm off probation.
When?
No, I get off probation like in about that February. But what happened on that?
No. When did you get off of probation for that?
February.
This February?
Yes, sir.
You're getting off or you're off?
I'm off.
Okay. But you were on when this happened.
Yes, sir.
But you were on probation with this, then you committed this offense? Okay. You know, criminal actions have consequences. We made that clear. You were on probation. You were convicted. And so while convicted of this crime of evading arrest or detention, you commit sexual assault on a child, a 17-year-old.
This is the judge's rawest moment, emotional, furious, and human. He reminds Daryl that everyone faces hard times, but not everyone crosses that line. We don't go out and sexually assault 17-year-olds. That's not just a statement, it's a verdict on character. The courtroom's silence here speaks volumes. Daryl's letter, meant to show remorse, instead reveals self-pity. And that contrast between what he says and what he did is the emotional heart of this case. If you're the judge, what would you do next? Is there any room for leniency left after this?
I have that right, correct? Okay. The court's going to move forward on this, but
Then, Judge, can I make my argument
yes,
before you do that?
yes, sir, you can.
Because I want you to look closely at that letter that he wrote you.
Yes, sir.
Clearing this all up and how much remorse he had for the child and what he did to her, because that letter is all about him, all about everything is always about him. Even in the pre-sentence report, there's not one thing in there that says, oh my gosh, what did I do to that girl? I wish I could help. I wish I could take it all back. Wish I could give her
And
innocence
she
back.
was, but there's 3 words. She touched me.
Yeah.
But you admitted to oral sex with her.
And he calls her the little accuser.
I
That
don't recall
Just-
saying nothing like that. You don't say nothing like that. And I actually, on the pre-sentence, I don't know if she wrote everything down, but I did.
They do.
Yeah. But I did.
They're real good about it, and they're real fair. The probation office
The
in
whole
the
time I was there.
Listen, when I speak, stop. Okay. The probation, it's a point I want to make. The probation office has a rich history of being fair. We have a 93% success rate for our probation. You think they're working against you? No, they're trying to get you across the finish line successfully. So don't say it's their fault, sir. They do their job accurately, and they take great pride in success in probations, people making mistakes, fixing it, and moving on and being the best they can be. So
And Mr.
don't
Newsom-
go toward the probation office is dishonest when you got 2 separate sets of statements made to me under oath at the plea hearing, and then here in the pre-sentence report, your words are 180 degrees different, and it tends to blame the 17-year-old. But you do say the right things in this letter. No, I was wrong. I take accountability for my action. I was going through a rough time in my life. Welcome to the world. Boy, don't we all from time to time, but we don't go out and sexually assault 17-year-olds. I mean, there are certain things that with the difficulties we all have every day in daily life, some difficulties affect our clear thinking. Well, it's pretty clear. You don't have oral sex with a child. after there's drinking and then drinking. Was this at your house?
Yes, sir.
Yeah. Well, who was responsible for applying alcohol to the children?
Right.
You were. Okay. 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 The pre-sentence report also states the mother of the victim.
The victim's mother's statement pulls this hearing out of the legal and into the personal. My daughter was supposed to be at a sleepover. That one line dismantles every excuse. The mother paints the real cost, trauma, betrayal, and the lasting mental impact. It's no longer about Daryl's regrets, but about a girl who trusted the wrong adult. In moments like this, the courtroom shifts from justice to heartbreak. You can sense the judge's tone hardening, because sympathy has officially left the building. And when the sentencing hits, it's not a surprise, it's a consequence.
My daughter was supposed to be at a sleepover. You were pouring the kids alcohol like they were grown at a bar. And this event has mentally impacted my daughter. There's something else here that's in this pre-sentence report, but it's not. You know what it says. You've read it, and it's not a good thing about your reputation. All right. Anybody else have anything to say? Mr. Ordwine, anything you would like to add?
Just wanted to say I apologize about everything to the mother, to the victim.
Yes, sir.
You know, I never meant for anything to happen. You know,
That's not, this says you admitted to intentionally or knowingly doing this, committing oral sex on the child.
none of the influence. You know, I made bad decisions. I made bad choices.
Well,
I regret it all.
let me just say that these sorts of crimes in this court generally result in the highest form of punishment. And you were looking at this case at no less than 2 nor more than 20 years confinement in prison. And juries regularly give the maximum when they believe the crime has been committed. And this court does as well. Here is the cap. Y'all agreed on a cap. The highest that the court can set is 5 years in prison. I now find you guilty beyond a reasonable doubt of the second-degree felony of sexual assault of the 17-year-old, and I am following this agreement. You are hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. You will be given credit for all time you have served in accordance with this case. You will also be required to register as a sexual offender. Those are laws the state of Texas requires. Failure to properly register can result in further prosecution for the requirement of failing to register as a sex offender. Do you understand what has happened today, sir? I just wished you would have had self-control, because you say good things, but yet your actions were different.
That's my past actions. And I guarantee you, I'm not that person.
Good. That's good. But, there's an old saying, what's in the past is never really in the past. It's still there. It has to be accounted for. Okay. That is all. Thank you.
5 years in prison and lifetime sex offender registration. That's the outcome. And honestly, it's light compared to what the law allows. The judge's closing line, "You say good things, but your actions were different," hits deeper than the sentence itself. It's a lesson in accountability. This isn't about one bad night. It's about how denial and blame can turn a second chance into a prison term. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and subscribe for more jaw-dropping courtroom breakdowns. Because in this courtroom, excuses don't survive. Only the truth does.